This is Suzanne Bechtel. I'm going to give you a lecture now on legal administration and technology. It's covered in Chapter 2 of Practical Law Office Management by Cynthia Trena Donis. We begin with the first part of this three-part series regarding functions of practice management. And I have highlighted the two primary objectives that are covered in this particular lecture, one of three lectures. Distinguish between office administration and practice management, and define total quality management. First of all, dispelling a myth. Many people assume that attorneys automatically make good managers. In truth, this is not necessarily so. Although lawyers have gone to school to learn about practicing law, many have no training or experience in management. One adage is, the best system for law office management is the system that involves the lawyers the least. So poor management, what happens is layoffs, mergers, and or closures. Signs of poor management include unhappy staff members and clients. The next thing to consider when on this chapter is that there is a difference between practice management and administrative management. Practice management refers to management decisions about how a law office will practice law and how it will handle its cases. Administrative management refers to management decisions relating to managing a law office, such as financial or personnel matters. So I'll give the example of a large firm I worked for. It was a nationwide firm and probably about 600 attorneys. And one thing that I was not accustomed to before working there, because I tended to, before that I would work for small law firms where this wasn't noticeable to me. But the lawyers work in practice of what are we going to specialize in, what the legal services are. They have the meetings about those topics as a group, and typically, a large group of partners. And you'll remember from the last chapter, a partner is a shareholder, a stakeholder in the practice of the law firm, and so they're earning money in a different capacity than the contract attorneys or the staff attorneys. The administrative management piece, what they did and what is common in large firms is they had a practice manager, lawyer, a partner who was managing partner. And that managing partner was more responsible with those financial management pieces that are discussed in the book, and also more of a liaison to the office administrator or office manager, however you want to put that. And they together handled more of the financial management and human resources management pieces. So just imagine this large practice of lawyers, a group of partners that are partners in the firm, managing practice management, but one person is the managing partner, and the managing partner of the firm and the office administrator work a little bit more hand in hand on the financial management and human resources management. So what are the overall functions of legal administration from the introductory standpoint? Management, as I pointed out, is the administration of people and other resources to accomplish objectives. And the functions of administration include these topics here: practice management, leadership, controlling, financial management, human resources management, planning, marketing management, organization, policies and systems, facilities management, office services management, and technology management. So that's the whole picture of the law firm that goes on, because you'll know at the top of that is the practice management. And then what you see around the rest of this is a lot of the administrative piece of management, and sprinkled in there leadership, controlling, and that sort of thing, is this intersection of the practice management and the legal administration. Practice management, as I pointed out, is a little different from the legal administration management. In practice management, they're defining the law firm's practice. Every law firm makes decisions regarding who is their primary clientele. They define the law firm's services, because once the law firm has decided who its clients will be, the next step is to decide exactly what services will be provided to the clients. And also defining the law firm's practice system needs. Once it's been decided what legal services will be provided to clients, the next step is to decide what practice systems and resources are needed to deliver those services. And that's a piece on, computer hardware, software, library issues, personnel issues, etc. And again, that last point on the last slide basically points to that liaison piece between a managing partner and a law office administrator. Next, we go to one area of practice management is quality. One particular type of quality management is called total quality management. This is a theory, theory I'm going to call it. Total quality management is a philosophy, as the book points out, not necessarily a theory, based upon knowing the needs of each client and allowing those needs to drive the legal organization at all levels of activity. The philosophies of it are: management has an overriding duty to ensure that the firm provides quality legal services. Quality service involves every person in the firm, and everyone must be committed and involved in the quality of the firm. And quality service is based not on management's or our own perception of quality, but on the perceptions of the client. And quality service depends on the individuals, the teams, and ultimately the organization's performance. And improvement of the system is constant. Back to the concepts of practice management, and I pointed out already, one of the first is defining the firm's practice. And the practice management is a topic that's sometimes left out of discussions with paralegals because they're typically not involved in these types of decisions. Nonetheless, practice management and the strategy of attracting and retaining clients is critical to the success of any law firm. As such, it is essential for the paralegal staff to know about the types of clients the firm provides services for, how the firm distinguishes its services from those of other firms, how the firm selects which cases and clients to work with, how important quality is, and what resources in terms of staff, marketing, and technology the firm uses to provide those services. What types of cases, again, going back to the start of the slide, remember that practice management is what types of cases do we want to take, and what's the long-term projection for those cases. What legal areas will we specialize, and should we focus on subspecialties? How many practice areas will we have? How much can we do well with the resources we have? And who will champion the practice areas and lead their development? Keeping this conversation simple, law firms, unless they're very large, do not have a tendency to work in every single area of the law. It's too hard. It's too expensive. It can't be done without, like I said, having a cadre, a large resource of staff and lawyers, etc. So the practice management and the definition of it is, are we going to specialize in personal injury? Are we going to specialize in something like bankruptcy or other consumer debt problems? We're going to take on some subspecialties of this larger picture. Given that like 50% of the United States lawyers are sole practitioners, this is a little bit more simply defined in a small law office because there's the sole practitioner with some hires working, even lawyer hires working for them. That idea is going to be usually a small practice, a boutique firm with maybe one or two areas of law that they work in, and maybe not so much deep down into the subspecialties of it because it becomes too much. It's really about being specialist in an area that becomes harder when you take on too much. So that's what the law firm is doing. It's specializing its practice. The other thing that they look at, that practice management is important to practice management, is that are we going to provide services to an industry or to a community? Like an industry being the firm that I worked for. I mentioned earlier, we did natural resource representation. So we were obviously serving an industry of natural resource. I mean, mining, oil and gas, drilling and production. Or the other question would be: are you going to attract everyday type of firm practice, like I mentioned earlier, bankruptcy clients or family law clients or elder law? Those are what services we're looking to provide. Is it going to be to a large group in the community, or is it going to be to a specific industry? Geographic area, of course, is another issue. I called, for example, a law firm that a friend referred me to that had an office in Sarasota and in like Inglewood, which those to me are faraway places between each other. Their geographic area was twofold, but then they closed down their Sarasota office because they needed to focus their geographic practice area into a smaller area. I don't know if it was too much clientele or too much work. I don't know. There are a lot of reasons for that could have happened. And then how do we attract the clients? This is marketing. This is by I mentioned in the previous chapters online lecture something about like of counsel attorneys as one of the cast of characters possible in a firm. Maybe that is a way they're going to decide to attract clients in one way. How will they market their business, their practice? How will they describe to the public what the practice is about? And how will we assure that the clients receive quality services? Total quality management techniques or philosophies such as total quality management is one way to help to ensure the client is receiving quality services. Another is, who are you hiring to practice there? Who are you hiring to help those who practice them there, practice at the firm? There are so many questions that come up with just this one topic of assuring quality services that the sky's pretty much the limit. But the idea is quality, and the idea is obviously to avoid malpractice. How will we hold on to the clients? What will be our basis for competition to differentiate our services from the next firm's services? I can think of situations like when I worked for in a probate firm, wills, trust, and estates firm. That's hard to hold on to those clients because there's so much incentive in Florida to move on. The newspaper that says come to our free lunch or come to our free continental breakfast. We'll have a guest speaker on taxes after death or whatever the case may be. So it's very difficult to hold on to clients, and this will fall back on things like the quality of the services, the people that have attracted those clients in the first place, the handshakes, the efforts at keeping clients and maintaining communication with them even after doing that last will and testament or trust, and the person walks out of the door and you don't do that. And to keep massaging those client relationships, it's going to be an issue. This lecture was based on our textbook, Practical Law Office Management by Cynthia Traynor Donis, published by Cengage Learning. And thank you very much. We'll move on. You can move on now to the second of the series, the three-part series on functions of legal administration. Thank you.